Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm joined by my co-host, Justin Williams, and we're here to help you make the most of your minerals and royalties. And in this episode, we're going to talk about how to transfer ownership of inherited mineral rights. And Justin, before we hit record, we were talking about different scenarios that are very common. And this is a question that I get over and over from listeners. And so we wanted to break this down and kind of do a bit of a deep dive on a couple of different common scenarios, from the standpoint of inheriting minerals and what you need to do in order to transfer those minerals into your name so that you can have marketable title. And we'll talk about all of what that means and how to go about this and all the different nuances and different options to help you avoid some of the headaches that a lot of mineral and royalty owners that inherit properties go through if the property was not put into their will or probated or, was just forgotten about.
You said it, Matt. And again, like you said, this is a very common question. And sometimes the first place that people start when it comes to inheriting mineral rights. And it's not one size fits all. I think everyone kind of assumes that this is the standard process, but it really can depend what you need to do with the property and where title is at with the property when you inherit it. So, Matt, we should probably set the stage and talk about why this is different than, let's say, personal property or personal effects. And that's because minerals are real property. So just like a home, they have to go through that formal legal process to transfer ownership. And we did a show, Matt, with Richard Winblad, and you'll mention that in just a moment, but he pointed out that minerals are real estate. They're real estate so far as they're in the ground, and then once they're produced, they're personal property. And that's something that can kind of trip people up. We don't see minerals necessarily as the same as a house when we first inherit them, but that's the case.
Yeah, you're absolutely right. And the interesting thing with minerals is it's not something that if you're not getting paid, it's easy to let them fall by the wayside, so to speak. So in other words, you had this ranch or the farm that the family owned and there weren't any wells drilled. And then eventually there is interest because now there are a bunch of horizontal wells that are permitted. Then you're getting offers and you get calls. And a lot of times, like we've mentioned many times before, the first time people find out that they inherited these types of interests is when they get a call from a landman asking if they're interested in selling or leasing. And that can be quite a surprise to people. And so what we want to do is just sort of give you the information you need so you don't put your heirs in that same boat down the road if you have minerals that you own that are in your name, or if you're figuring out you're in that situation, you just got that phone call and you're trying to scramble to find out more about what it is you own, what do you need to do to get the ownership in your name because it's, it's still in your ancestor's name. That's what this episode is about. Now, I will put the disclaimer out there before we get too much further that this should not be construed as legal advice. This is being shared for informational purposes only. You definitely need to consult with an attorney that's licensed to practice in the state where you own your minerals to get advice specific to your situation. So with that in mind, there are really 3 episodes we've covered bits and pieces of this in the past. Like Justin alluded to, episode 85, where we had attorney Rick Winblad on to talk about probate and marketable title. We had episode 67, where we had estate planning and mineral rights with attorney Ben Kinney. And then we had an episode more recently using a ladybird deed to streamline inheritance, which is episode 215, which is a little known way that you actually can avoid having to go through probate in some cases. In only, I think, 5 states accept ladybird deeds. But if you're in one of those 5 states, it's worth understanding what it is and then talking to your attorney about whether or not that's an option for you. But the thing that really triggered this episode, Justin, was a question that I got from a listener recently. And this, again, is in a long line of very similar questions that I've gotten from other listeners. And this question came in from Cindy, and she said, my husband had mineral rights in North Dakota, Texas, and New Mexico. They were producing, and he was receiving royalties from North Dakota interests. We've been talking about transferring the deeds to either both our names or to our family trust. Sadly, her husband passed away earlier this year after an extended illness before they could do the transfer. She did say that they had a will drawn up to show that the surviving spouse would inherit assets. And then she also set up power of attorney documents with herself as her husband's attorney in fact, and then her son as hers. But unfortunately, the mineral deeds are still in his name alone. So first of all, Cindy, my condolences on the passing of your husband. And I know that's got to be a difficult situation. And then having to deal with all this on top of that. But she asked, like, here's the crux of her question. Since she could no longer drop a deed to transfer after her husband's death, she contacted a North Dakota oil and gas attorney. They've been working on doing probate proceedings, and they're wrapping things up. And they'll be recording the deeds into her name for the North Dakota interests. She says, however, I have not done anything about the Texas and New Mexico minerals. I don't want to hire attorneys for those states, but I don't know what to do as I cannot legally lease or sell the minerals while still in my husband's name. And so, Cindy, that's a very tough situation because generally, if you're in that situation where you don't have those proactively put into a different type of an entity like a trust or an LLC, really the only way that I'm aware of, and again, I'm not an attorney, but again, aside from some fringe cases or some unique situations with respect to heirship proceedings, is generally you have to go through probate, and it's called ancillary probate when you have to go through probate in another state. So, for example, let's say you have a relative that passed away in Colorado. The will that they had, puts you down as the heir to the mineral rights. That will was, and the minerals are in Texas, let's say. That will was probated in Colorado. And you have to take that probate from Colorado and the will and take that into Texas and then file that in Texas in order to get the minerals transferred over in Texas. So there's like each state where those interests are located, you have to go through what's called an ancillary probate, where they probate a foreign will. They take all the court documents and the letters and all the things from the state where the will was originally probated. And it's a fairly quick and easy, streamlined process. And as far as the other states you have to go through where the minerals are located. But unfortunately, that is the legal process through which a deceased person's estate is administered and distributed to heirs under court supervision. And that's done so that, no funny business happens, right? So if somebody's will says, my grandkids get the mineral rights, that the court makes sure that the grandkids get the mineral rights, and crazy Uncle Eddie didn't come in and try to steal them away from the rightful heirs. And so, that's the kind of situation, unfortunately, and the process you have to go through. And it's not something that is easy or cheap per se. It takes time, but it is necessary in order to get marketable title. Now, Justin, you want to talk about what we mean when we say marketable title?
Yeah, absolutely, man. I think this is something that can confuse a lot of folks when it comes to minerals. The operators are doing title work on your property, and I know I have the situation often where they came to me and we needed to do some kind of paperwork to shore up their questions in title. But Matt, when you have that experience, you kind of assume, oh, okay, well, this is all ready to go. This is as good as it needs to be. But that's not always the case. When we're getting into a situation where maybe we're selling the minerals, or maybe there's another situation going on, having marketable title is really what's required. And that's that you can show a clear chain of title from one person to another and what that ownership percentage is. And Matt, you mentioned probate, and it is the way that is most common that you see. It's also something that others are going to be looking for to establish marketable title. But there are situations where operators may pay on something even though the title is not marketable, let's say.
Yeah, that's a great point. And it could be because the interest is so small and the risk is very low. For example, like if you were the rightful heir and you had that in a will documented and you're getting, less than $1,000 a year, they're going to look at that and say, well, this is the rightful heir. They don't have marketable title, but we're comfortable. We feel okay paying them or continuing to pay that family because, of the proof that they've provided. Now, that's totally at the discretion of the operator. I would say most are going to require that you have marketable title in order to put you into pay status. If there is a question about who's the rightful owner, they'll just put it into suspense. And then eventually, if you don't go through that process, they'll escheat those funds to the state to administer. And then you'll have to go through that whole process to claim those missing funds, so to speak, through that whole process. But, I will say, because minerals are real estate, like Justin mentioned, that's something that Rick Winblad mentioned in his interview, that some estate attorneys don't realize that mineral rights are a form of real property. And so they may not know how to handle that properly. So that's probably one thing to make sure if you're going through this and you're trying to find an attorney, is that they're familiar with oil and gas properties, and then obviously estate planning as well. And that can be somewhat of a niche thing. Not all estate attorneys understand minerals and oil and gas law and things like that. And so finding somebody that can handle both is definitely a benefit. And unfortunately, this whole probate thing, it's not based on the value of the property. So if you have a property that's only worth a few $100s or a few $1,000s, you still have to go through that probate process. And that can be several $1,000s to go through and, attorney's fees. So, if you're talking about a property that's worth, $5,000 and it's going to be $5,000 to go through probate, then, you can, unless it's got sentimental value, you can argue the benefit of doing that. And, you just let it sit there and kind of wait until maybe the value goes up if there's wells that are drilled or something that happens. But that's unfortunate. And that is the reality. And you can avoid that, again, if you had proper estate planning, and you can avoid that expense and the time of having to go through probate. And so, Justin, you want to talk about what some of those different options are? Again, we're talking about a situation of maybe being more proactive here and setting yourself up for your heirs up for not having to go through what you went through. But do you want to talk about some of those alternatives to a full probate?
So, Matt, like I said at the beginning, it's not one size fits all. So there are several different ways that you can go about this. And an estate attorney can really is the best one to guide you based on your unique situation and taking time to look at that. But Matt, trusts are a very common way of doing this. I would say that that's probably the most common these days. However, there are pitfalls with each of these options. So with trust, when we did our show with Richard Winblad, he had a wonderful story to tell about Bing Crosby and how Bing Crosby had a trust. However, the trust was never funded. And so many years later, it was discovered that he had mineral ownership in another state. And that was something, Matt, where because it wasn't funded, they had to go through probate and do the same process that everyone else has to, even though you would think that Bing Crosby, being who he is, had the best estate attorneys in the world and, would have caught everything. And sometimes it really comes down to what you don't remember, you can't deal with. On top of trust, Matt, there's other ways. LLCs are becoming more popular as a way to hold the properties. We've talked some in previous episodes about how the ownership of minerals has been fractionalized over the generations. And one of the ways that you can help to prevent that happening in future generations is to have an LLC and include your heirs there. So, Matt, that is a way that can be handled. It's more complicated than that. So, again, get with an estate attorney on that. But there's also some other ways, Matt, that are less common. I know pour-over wills are something that you hear quite often, and that can be in combination with a trust, and then ladybird deeds.
Yeah, and one note on the pour-over will, that term basically is a catch-all for assets that were not explicitly listed in the will. It's kind of a safety net for assets that are not transferred into a trust during that person's lifetime. So it basically says that any property requiring probate should be transferred into the trust and then distributed according to the trust terms. And that's that situation that Justin mentioned with Bing Crosby, where those minerals didn't go through probate. The trust wasn't funded with that property, but that pour-over will specified that property requiring probate should be placed into the trust and administered according to the terms of the trust. And that's exactly what happened. And so while his grandson did have to file probate, it was pretty straightforward for them to determine who should have gotten those minerals because Bing Crosby's original estate plan outlined, who got what based on the different types of property. And so it just kind of fell into that whole cascading, heirship process once it was included into that. So in terms of other options, like Justin said, there's some different combinations of those and there's different pros and cons. So some thought with LLCs alone, you may not be able to totally avoid probate. For example, if it is the ownership in the LLC has to go through probate potentially, even though the minerals themselves may still exist and sit in the LLC. And so that doesn't need to change. That's already filed of record with the county. But the issue is that if the operating agreement is not well drafted and addresses the succession situation, then you might have to go through probate on the ownership rights of that LLC. So you got to be very careful and make sure your attorney drafts a good operating agreement that's going to provide the things you need to happen in terms of transferring the LLC membership into a revocable trust or some other things like that. And so that can be done. But then, like Rick Wimblad mentioned, and there's pros and cons. And so if you have to go through a trust anyway, there's some argument to be made that why not just put the minerals in the trust directly to begin with, and then you don't have to go through that whole situation, that nested or kind of layered approach, which can cause some additional expense or complications. But again, it really just depends on your personal situation. Who else is a member or a partner in that LLC, how that needs to be managed and all of that. So there's definitely pros and cons, but in general, those LLC trusts are two options for being able to convey to heirs without having to go through probate. And then another potential situation is, like we mentioned earlier, is that ladybird deed. And ladybird deed is unique in that it allows you to basically specify the heirs while you're living, and then the interest will basically be passed on to those heirs without having to go through probate, because it's already sort of outlined that, okay, when I die, this is who's going to inherit the property, and that deed is in itself conveying the interest upon your death. And so these are referred to as an enhanced life estate deed. And then the beneficiary in that deed is sometimes referred to as a remainderman or a remainder beneficiary. And so there's definitely pros and cons, especially if there's any sort of family disputes, which I've seen time and time again around, when there's a lot of money at stake and people, will start grabbing and say, oh, I want my share, or whatever. And if there's issues, then it can be maybe not as strong as other ways to make sure that you protect exactly who's going to get what. But, that is something that you can maintain control of the property through your lifetime, but then it transfers the interest upon your passing to your heirs. So that can be a great option as well. Again, that's only really allowed in about 5 states. So unfortunately, it's not a thing that every state will accept, but certainly worth talking to your attorney if that's an option, if that's something you want to set up that might be a little bit simpler and set your heirs up to not have to go through probate. The other thing too, I'll say is, like, when you get into a situation of multiple states, then that's where some of these more complex, like a trust or an LLC, becomes probably a little more robust, because you may be able to do the ladybird deed for some interest in Texas, for example, but then the interest in North Dakota, New Mexico, in this situation, maybe you're still having to go through probate anyway, so you might as well go through and do something different that catches all of the different interests. So, like Justin said, I think it really boils down to needing to have specific advice based on your situation. But Justin, you want to talk about some other kind of things to look for when hiring an attorney? Because that's probably the next step here. The advice really is from this episode is know these options and then contact an attorney licensed in the state where your minerals are located. Do you want to talk about kind of what to look for there?
Yeah, man, absolutely. And this is something that you would think that it was pretty standard information, but that's certainly not the case. And Matt, I've had the personal experience of working with attorneys that thought they were like stocks, which could be a huge mistake in the estate planning process. And Matt, the most practical tip I would give is, if you have an oil and gas attorney you've been working with in that state or that you've contacted that you like, ask them. They typically know the estate attorneys. They know which ones are pretty good at minerals. So that's a great place to start. Some other ways to kind of interview estate planning attorneys is ask them about oil and gas, ask them what they know about minerals, and write that down. Ask somebody who knows more than you, or if you know enough to be able to kind of understand what they're saying and whether it seems to be correct or not. That can be a wonderful place to start. Matt, there are multi-state considerations, so it is possible, and there are times that there are firms who often represent gas-producing states. And so you might be able to work with a firm that has multiple attorneys. Something that I think people don't realize is they have to be licensed in multiple states to work across state lines. It's not all that often that you find a attorney that can do work in 4 or 5 states. Typically, it's 1 or 2 at max.
Yeah, and one of the things I will say, there's now these other alternatives to consider that may or may not actually give you marketable title, but it may allow you to get into pay status. So one kind of quick and easy that is not that can be contested is what's called an affidavit of heirship. And that's basically a sworn statement that's signed by individuals with knowledge of the deceased family's history, who the legal heirs are, and all of those types of things. And then it's filed in the county where the minerals are located. And some operators will accept that. And again, it goes back to that situation that we mentioned earlier. If it's a very low value, low risk thing for them, they may say, okay, yeah, we'll accept that as far as proof of ownership and at least to get you paid minerals. Now, that affidavit of heirship would not be considered marketable title. You wouldn't get marketable title after filing that. A certain period of time may have to transpire with nobody contesting it, or ultimately you need to go into a more rigorous option like a determination of heirship. In some states, you can do that if the time frame for filing for probate has passed, like it's been decades since an ancestor passed away that you found out about these minerals. You might be able to knock out a couple of different legs in that family tree. So let's say that great grandpa passed away, it never got passed on to your grandmother or to your mom and then to you. And so then you can maybe go directly from your great grandparent to you using that determination of heirship, where you basically outline that whole inheritance process and who should have gotten what, and you provide all the documentation to the courts. And then if they agree, they'll say, yep, here are the heirs and here's the percentages that they get, so to speak. And then that becomes basically proof that you're the rightful heir. Now that is, again, it's only accepted in certain states and certain conditions. It's not always something you can do. You have to sometimes just go ahead and bite the bullet and go through probate. And so, yeah, ultimately there's limitations to some of these other alternatives. And ultimately, if you want to make sure that you have the people that you want to inherit these properties, which may be different than what the state intestacy laws. In other words, if you don't have a will, who's going to get what? Like, if you it may go to people that you don't want to inherit these assets unless you specify it in a will. And then again, to protect and make sure your heirs don't have to go through that whole probate process, putting it into a trust is a great option. And then again, communicating this to your attorney, what your wishes are, and then your family, what the wishes are, and having that clearly documented will make sure that, if you're in this situation, unfortunately, like, the listener that wrote in, or if you are in a situation, you've just inherited these properties and you're just trying to figure this all out. Once you figure it out for yourself and go through the expense and time of going through probate, talk with your estate planning attorney to get it into the type of an entity that'll prevent your heirs from having to go through the same headaches that you went through. So I think that's the other takeaway here. And so ultimately, this is an amazing asset that we're given and, get to enjoy, and let's pass it down and ensure that proper legal transfer to those future generations, I think is the moral of the story here. And, if that property is not worth very much, you can do the DIY route. So listener David, who has written in, he's got several small interests in a particular state that he doesn't live in. He's going through the probate process and just following the documents himself. So it's, potentially, again, get legal advice, get help from an attorney, but technically you do not need an attorney to go through that. You have to file those documents. The problem is, you can make a lot of mistakes. It can be time consuming, expensive. It's not going to get done if it's done improperly. But if you get help from somebody, there is potentially a way that you can, maybe get attorney's help with one of them. But if you have a bunch of other states, and it's very similar, you could maybe, get the template and fill it out and then go that route as well. But there's risk to that, obviously, as well, that something doesn't get done correctly, and then you still are left without marketable title. But, for very small interests that aren't worth very much, it could be an option.
Yeah, you said it, man. And it's, really the first step is to speak with somebody, and most attorneys will do a free consultation with you, and they'll kind of give you an idea if they're who you need to be talking to. So don't be afraid to do that. And then, Matt, we mentioned that sometimes as far as the operator is concerned, getting payments flowing to you is not always the same battle. So you can always ask the operator, too, what they're looking for from you in that situation. And like our listener's question, that can be a bit stressful. If you've got a situation where you're receiving these payments, you're not necessarily counting on these payments, but you don't want to ask too many questions because you're afraid those payments will stop to flow. And so it can be a rough situation or a tough situation to be in.
Yeah, absolutely. All right. Well, as always, you can find links to the references we mentioned in this episode in the show notes, which can be found at mineralrightspodcast.com. If you have a question you'd like us to answer, you can send it to feedback@mineralrightspodcast.com. Thanks again for listening. Thanks, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.